Chapter 21, Part 2 of Social Statics by Herbert Spencer. This LibriVox recording is in the public domain. Recording by Thomas Bosk. Social Statics, or the conditions essential to human happiness specified, and the first of them developed, by Herbert Spencer. Chapter 21, The Duty of the State, Part 2. Section 6. But after all, it is not the setting up of this or that system of jurisprudence which causes the intercourse of men with each other to be equitable or otherwise. The matter lies deeper. As with forms of government, so with forms of law. It is the national character that decides. The power of an apparatus primarily depends not on the ingenuity of its design, but on the strength of its materials. Be his plan never so well devised, his arrangement of struts and ties and bolts never so good, his balance of forces never so perfect. Yet if our engineer has not considered whether the respective parts of his structure will bear the strain to be put upon them, we must call him a bungler. Similarly with the institution maker. If the people with whom he has to deal are not of the requisite quality, no cleverness in his contrivance will avail anything. Let us never forget that institutions are made of men, that men are the struts, ties, and bolts out of which they are framed, and that, dovetail and brace them together as we may, it is their nature which must finally determine whether the institutions can stand. Always there will be some line of least resistance, along which, if the humanity they are wrought out of be not strong enough, they will give way, and having given way, will sink down into a less trying attitude. Thus it is, amongst other things, with judicial mechanisms. No matter how admirably devised, their results will be good only in proportion as the nation is good. The instrumentalities by which they are to act, judges, juries, constables, witnesses, gaolers, and the rest, must be units of the people, will, on the average, be marked by the same imperfections as the people, and though the system they are set to work out be perfect, yet will the badness of their characters degrade its acts down to a level with the general conduct of society. That justice can be well administered only in proportion as men become just, is a fact too generally overlooked. If they had but trial by jury, says someone, moralizing on the Russians, but they can't have it. It could not exist amongst them. Even if established, it would not work. They lack that substratum of honesty and truthfulness on which alone it can stand. To be of use, this, like any other institution, must be born of the popular character. It is not trial by jury that produces justice, but it is the sentiment of justice that produces trial by jury, as the organ through which it is to act. And the organ will be inert unless the sentiment is there. These social forms which we regard as so potential are things of quite secondary importance. What mattered it that the Roman plebeians were endowed with certain privileges when the patricians prevented them from exercising those privileges by ill treatment carried even to the death? What mattered it that our statute book contained equitable provisions, and that officers were appointed to enforce them when there needed a Magna Carta to demand that justice should neither be sold, denied, nor delayed? What matters it even now that all men are declared equal before law, when magistrates are swayed by class sympathies and treat a gentleman more leniently than an artisan? If we think that we can rectify the relationships of men at will, we deceive ourselves. What Sir James Mackintosh says of constitutions, that they are not made but grow, applies to all social arrangements. It is not true that once upon a time men said, "Let there be law," and there was law. Administration of justice was originally impracticable, utopian, and has become more and more practicable only as men have become less savage. The old system of settling disputes by personal contest and the new system of settling them by state arbitration have coexisted throughout all ages, the one little by little usurping the place of the other, outgrowing it. It was only after some advance had been made that the civil power could get recognized at all as a maintainer of rights. The feudal baron with castle and retainers maintained his own rights, and would have considered himself disgraced by asking legal aid. Even after he had agreed to regard his suzerain as umpire, it was still in the lists and by the strength of his arm and his lance that he made good his cause. And when we remember that equally amongst the lords and labourers this practice lingers even now, that we have still duels, which it is thought dishonourable for a gentleman to avoid by applying to a magistrate, that we have still pugilistic fights, which the people try to hide from the police, we are taught that it is impossible for a judicial system to become efficient faster than men become good. It is only after public morality has gained a certain ascendancy that the civil power gets strong enough to perform its simplest functions. Before this, it cannot even put down banditti. Border forays continue in spite of it, and it is bearded in its very strongholds as amongst ourselves by the thieves of Whitefriars but 2 centuries ago. Under early governments, the officers of law are less friends than enemies. Legal forms are habitually used for purposes of oppression. Causes are decided by favoritism, bribery, and backstairs intrigue. The judicial apparatus breaks down under the work it has to do, and shows us in a Jonathan Wild, a Judge Jeffreys, and even a Lord Chancellor Bacon, how inevitably its several parts are rendered inoperative by a generally diffused wickedness. Of course the efficiency of present and future systems of jurisprudence must be determined by the same influences. Of our own legal arrangements we may say, what Emerson has well said of institutions generally, that they are about as good as the characters of men permit them to be. When we read of orange magistrates, who become aggressors rather than protectors, of policemen who conspire with each other to obtain convictions that they may be promoted, and of the late Palace Court, whose officers habitually favored the plaintiff with the view of inducing men to enter suits there, we find that now, as of old, judicial protection is vitiated by the depravity of the age. Nevertheless, it is probable that we are ripe for something better than we have. The universal disgust with which law is regarded may be taken as evidence of this, as evidence, moreover, that a change is at hand. But it is not likely that the mode of administering justice lately pointed out as the proper one is immediately feasible. Seeing that men, by not having yet recognized it as theoretically right, show themselves considerably below the state to which it is natural. This, however, is no reason for not advocating its adoption. For what was said in the last chapter respecting an equitable form of government may be here said respecting an equitable system of law, that the power quietly to establish it is the measure of its practicability. Section 7. By dispersing that haze of political superstition through which the state and its appendages loom so large, the foregoing considerations suggest a somewhat startling question. For if when men's savageness and dishonesty render the administration of justice most necessary, it is impossible, if it becomes possible only in proportion as men themselves become just, and if that same universal uprightness, which permits the administration of justice to become perfect, also makes it needless, as it evidently must, then we may naturally ask, can the state really administer justice at all? Does it, looking at society as a whole, secure to the people any fuller enjoyment of their rights than they would have without it? May we not conclude that it takes away from men's liberties in one direction as much as it gives in another? Is it not a mere dead mechanism worked by a nation's moral sense, neither adding to nor deducting from the force of that moral sense, and consequently unable to alter the sum total of its effects? A strange idea, this, some will think, and so at first sight it seems. We have such a habit of regarding government in its protective character, and forgetting its aggressive one, that to ask whether the rights it secures are not about balanced by the rights it violates, seems almost laughable. Nevertheless, we shall find that on drawing up a debtor and creditor account, the absurdity of the doubt disappears, passing over those ruling powers of the East, which in return for the small amount of security they guarantee, are in the habit of confiscating, under one pretense or another, any property not efficiently concealed by the unfortunate owners, and which, in some cases, push their exactions so far as to have to give back for seed in the spring a part of that crop they had taken from the husbandman at the previous harvest. Passing over, too, those middle-aged systems of government, under which protection, such as it was, had to be purchased by the resignation of personal freedom, let us institute as favorable a comparison as possible. Let us take the relatively good governments we know now, and setting down on the one side the benefits conferred, and on the other the evils inflicted, let us strike a balance between them. Under the head of obligations may be entered the efficient curb which our police system puts upon offenses against person and property. Our courts of law, too, with all their defects, afford a partial defense against civil injuries, which needs setting down in the estimate, and to these must be added what far outweigh them both: that sense of habitual security, and that consequent ability to fearlessly carry on the business of life, which are produced by the mere presence of an active civil power. After deducting from these a heavy discount on the score of shortcomings, there unquestionably remains a large surplus of benefit for which the state may claim credit. Turn we now to the per contra statement. As the first item on the list, there stands that gigantic injustice inflicted upon 19/20ths of the community by the usurpation of the soil, by the breach of their rights to use of the earth. Chapter 9. For this the civil power is responsible, has itself been a party to the aggression, has made it legal, and still defends it as right. Next comes the trespass committed against the many, subordinating them to the few, and forcing them to obey laws to which their consent was never asked. Note again the tyrannies accompanying national defense, the impressments and militia drawings, the continuous abnegation of liberty in the persons of soldiers and sailors, ending not unfrequently in the sacrifice of their lives. Remember also how our rights are trenched upon by commercial restrictions, and how men are not only prevented from buying and selling where they please, but are debarred from following certain occupations until they have bought government permits. Nor let us forget the penalties that until lately so seriously transgressed religious freedom. Penalties which, as the Anti-State Church Association can show, have by no means disappeared. And all these together, with the many minor restrictions hedging us about, are accompanied by those never-ceasing incursions made upon our property by the tax-gatherer and the officers of customs and excise, by poor-rate collectors and church-wardens. Measuring wrongs, as we must, by the degree in which they limit the exercise of faculties, let us now add up the two accounts and contrast their sum totals. On the one side, government partially saves us, only partially, mind, from those assaults, robberies, murders, cheatings, and kindred injuries, to which, were there no such institution, the existing immorality of men would expose us. These we must imagine to be distributed over the community at large, and over the life of each citizen, and then conceive to what average restriction on the free exercise of faculties they would be equivalent. On the other side, government itself transgresses men's liberties by the monopoly of land, by the usurpation of power, by restrictions on trade, by the slavery and death of thousands of soldiers, by the ruin of hundreds it ought to protect, by favoritism to creeds and classes, by the civil functions it makes imperative, by petty restraints too numerous to name, but above all, by a remorseless taxation, which affecting 7/8 of the nation as it does, by abstracting a large percentage from earnings already insufficient for necessaries, virtually obliterates in great measure the spheres needed for the development of their natures. We have now to suppose these manifold limitations to the free exercise of faculties averaged like the others, and then to ask ourselves whether the two averages are or are not equal. Is the question after all so very irrational? Is not the answer doubtful? Nay, indeed. Consider it rightly, and the answer is not at all doubtful. It is very certain that government cannot alter the total amount of injustice committed. The absurdity is in supposing that it can, and supposing that by some ingenious artifice we may avoid the consequences of our own natures. The civil power no more does what to the careless eye it seems to do, than the juggler really performs his apparent miracles. It is impossible for man to create force. He can only alter the mode of its manifestation, its direction, its distribution. The power that propels his steamboats and locomotives is not his making. It was all lying latent in the coal. He telegraphs by an agent set free during the oxidation of zinc, but of which no more is obtained than is due to the number of atoms that have combined. The very energy he expends in moving his arms is generated by the chemical affinities of the food he eats. In no case can he do anything but avail himself of dormant forces. This is as true in ethics as in physics. Moral feeling is a force by which men's actions are restrained within certain prescribed bounds, and no legislative mechanism can increase its results one iota. By how much this force is deficient, by so much must its work remain undone. In whatever degree we lack the qualities needful for our state, in the same degree we must suffer. Nature will not be cheated. Whoso should think to escape the influences of gravitation by throwing his limbs into some peculiar attitude would not be more deceived than are those who hope to avoid the weight of their depravity by arranging themselves into this or that form of political organization. Every jot of the evil must in one way or other be born, consciously or unconsciously, either in a shape that is recognized or else under some disguise. No philosopher's stone of a constitution can produce golden conduct from leaden instincts. No apparatus of senators, judges, and police can compensate for the want of an internal governing sentiment. No legislative manipulation can eke out an insufficient morality into a sufficient one. No administrative sleight of hand can save us from ourselves. But must not this imply that government is of no use whatsoever? Not at all. Although unable to alter the sum total of injustice to be supported, it can still alter its distribution. And this is what it really does. By its aid, men, to a considerable extent, equalize the evil they have to bear, spread it out more uniformly over the whole community, and over the life of each citizen. Entire freedom to exercise the faculties, interrupted by entire deprivations of it, and marred by the perpetual danger of these deprivations, is exchanged for a freedom on which the restrictions are constant but partial. Instead of those losses of life, of limb, or of the means of subsistence, which, under a state of anarchy, all are liable to, and many suffer, a political organization commits universal aggressions of comparatively mild type. Wrongs that were before occasional, but crushing, are now unceasing, but bearable. The system is one of mutual assurance against moral disasters. Just as men, whilst they cannot prevent fires and shipwrecks, can yet guarantee each other against ruin from these, by bearing them in common and distributing the injuries entailed over long periods of time, so although by uniting together for judicial purposes men cannot diminish the amount of injustice to be borne, they can, and do, insure themselves against its otherwise fatal results. Section 8. When we agreed that it was the essential function of the state to protect, to administer the law of equal freedom, to maintain men's rights, we virtually assigned it to the duty, not only of shielding each citizen from the trespasses of his neighbors, but of defending him, in common with the community at large, against foreign aggressions. An invading force may violate people's rights as much as, or far more than, an equal body of felons. And our definition requires that government shall resist transgression in the one case as much as in the other. Protection. This is what men seek by political combination, and whether it be against internal or external enemies matters not. Unquestionably war is immoral, but so likewise is the violence used in the execution of justice. So is all coercion. Ethical law is as certainly broken by the deeds of judicial authorities as by those of the defensive army. There is, in principle, no difference whatever between the blow of a policeman's baton and the thrust of a soldier's bayonet. Both are infractions of the law of equal freedom in the persons of those injured. In either case we have force sufficient to produce submission, and it matters not whether the force be employed by a man in red or by one in blue. Policemen are soldiers who act alone. Soldiers are policemen who act in unison. Government employs the first to attack in detail 10,000 criminals who separately make war upon society, and it calls in the last when threatened by a like number of criminals in the shape of drilled troops. Resistance to foreign foes and resistance to native ones, having consequently the same object, the maintenance of men's rights and being effected by the same means, force, are in their nature identical, and no greater condemnation can be passed upon the one than upon the other. The doings of the battlefield merely exhibit in a concentrated form that immorality which is inherent in government, and attaches to all its functions. What is so manifest in its military acts is true of its civil acts, that it uses wrong to put down wrong. Defensive warfare, and of course it is solely to this that the foregoing argument applies, must therefore be tolerated as the least of two evils. There are indeed some who unconditionally condemn it, and would meet invasion by non-resistance. To such there are several replies. First, consistency requires them to behave in like fashion to their fellow citizens. They must not only allow themselves to be cheated, assaulted, robbed, wounded without offering active opposition, but must refuse help from the civil power, seeing that they who employ force by proxy are as much responsible for that force as though they employed it themselves. Again, such a theory makes specific relationships between men and nations look needlessly utopian. If all agree not to aggress, they must as certainly be at peace with each other as though they had all agreed not to resist, so that, whilst it sets up so difficult a standard of behavior, the rule of non-resistance is not one whit more efficient as a preventive of war than the rule of non-aggression. Moreover, this principle of non-resistance is not deducible from the moral law. The moral law says, do not aggress. It cannot say, do not resist. For to say this would be to presuppose its own precepts broken. As explained at the outset, Chapter 1, morality describes the conduct of perfect men, and cannot include in its premises circumstances that arise from imperfection. That rule which attains to universal sway when all men are what they ought to be, must be the right rule, must it not? And that rule which then becomes impossible of fulfillment must be the wrong one? Well, in an ideal state, the law of non-aggression is obeyed by all, is the vital principle of everyone's conduct, is fully carried out, reigns, lives. Whereas in such a state the law of non-resistance necessarily becomes a dead letter. Lastly, it can be shown that non-resistance is absolutely wrong. We may not carelessly abandon our rights. We may not give away our birthright for the sake of peace. If it be a duty to respect other men's claims, so also is it a duty to maintain our own. That which is sacred in their persons is sacred in ours also. Have we not a faculty which makes us feel and assert our title to freedom of action, at the same time that, by a reflex process, it enables us to appreciate the like title in our fellows? Did we not find that this faculty can act strongly on behalf of others, only when it acts strongly on our own behalf? And must we assume that, whilst its sympathetic promptings are to be diligently listened to, its direct ones are to be disregarded? To suppose this is to suppose an incurable defect in our moral constitution, is to suppose that the very sentiment intended to lead us will itself mislead us. No, we may not be passive under aggression. In the due maintenance of our claims is involved the practicability of all our duties. Without liberty of action, without rights, we cannot fully exercise our faculties, and if we cannot fully exercise our faculties, we cannot fulfill the divine will. And if we allow ourselves to be deprived of that without which we cannot fulfill the divine will, we virtually neglect that will. But how, if all coercion is immoral? Will it not follow that it is immoral to use violence in opposing a trespasser? Certainly. Then either alternative is wrong? Just so. The law of right conduct has been broken, and this dilemma is the consequence. Action and reaction are equal. The blow dealt at morality in the person of the injured cannot end with itself. There must be a corresponding recoil. The first evil gives rise to an equivalent second, whether it is met by resistance or not. The assertion looks strange, will perhaps be incredible to many, nevertheless it must be made. And all we can say of this seeming paradox is, that it shows how actions lapse into a moral chaos when once the equilibrium of men's relationships is destroyed. Thus we find that the principle of non-resistance is not ethically true, but only that of non-aggression, that hence a government is justified in taking up a defensive attitude towards foreign enemies, and that the abstract criminality undoubtedly attaching to such a proceeding is the same criminality which pervades the administration of justice, is the same criminality of which government is itself a consequence. Section 9. Of international arbitration we must say, as of a free constitution, or a good system of jurisprudence, that its possibility is a question of time. The same causes which once rendered all government impossible have hitherto forbidden this widest extension of it. A federation of peoples, a universal society, can exist only when man's adaptation to the social state has become tolerably complete. We have already seen that in the earliest stage of civilization, when the repulsive force is strong and the aggregative force weak, only small communities are possible. A modification of character causes these tribes and satrapies and gentes and feudal lordships and clans gradually to coalesce into nations, and a still further modification will allow of a still further union. That the time for this is now drawing nigh seems probable. We may gather as much from the favor with which such an arrangement is regarded. The recognition of its desirableness foreshadows its realization. In peace societies, in proposals for simultaneous disarmament, in international visits and addresses, and in the frequency with which friendly interventions now occur, we may see that humanity is fast growing towards such a consummation. Though hitherto impracticable, and perhaps impracticable at the present moment, a brotherhood of nations is being made practicable by the very efforts used to bring it about. These philanthropic enthusiasms, which the worldly wise think so ridiculous, are essential parts of the process by which the desideratum is being wrought out. Perhaps no fact is more significant of the change going on than the spread of that non-resistance theory lately noticed. That we should find sprinkled among us men who from the desire to receive this ultra-humane doctrine do violence to their perceptions of what is due to themselves, cannot but afford matter for congratulation. Unsound as the idea may be, its origin is good. It is a redundant utterance of that sympathy which transforms the savage man into the social man, the brutal into the benevolent, the unjust into the just, and taken in conjunction with other signs of the times, prophesies that a better relationship between nations is approaching. Meanwhile, in looking forward to some all-embracing federal arrangement, we must keep in mind that the stability of so complicated a political organization depends not upon the fitness of one nation, but upon the fitness of many. End of Chapter 21, Part 2.